So, Mike, I know you've been very, very deeply affected by the recent news about Horizon Worlds. You've done very well to conceal it,
Yes.
but I know it's really hit a kind of deep fiber of your being, the fact that Meta will no longer be creating new games for it. It's essentially putting all the kind of funding out of it. You know, its grand plan for a metaverse is seemingly dying. And yeah, it's going to be tough for you as a non-user. But anyway, Horizon Worlds has a prompt as a user, which is discover worlds. So as a kind of homage to this kind of no longer platform, I want you to tell me how you would discover worlds.
Well, I was going to say, the world that I'm discovering, or at least the world that I'm remembering, is the very last message I ever received from Mark Zuckerberg was the night before the company changed its name from Facebook to Meta. He sent me a message saying that they were going to be making a really big announcement in the morning about VR and related things. And he thought I would be really excited and really interested in it. And he couldn't wait to hear my feedback on it. And then the next morning they made the announcement. I was like, wait, why would he think I would care about this at all? I never used Horizon Worlds. I don't quite even understand how you would use it. I never bothered to learn, and maybe that's on me. So maybe it's on me as to why it's shutting down, but it just never got me. But what worlds are you going to discover, Ben?
Well, I mean, I don't like foretelling the future, but the world I've been inhabiting this week has been the Trust and Safety Summit here in London, which has been a gathering of the kind of great and good of trust and safety and internet regulation. And many of our listeners have been there. I spoke to a number of them, and they were all saying very nice things. But there's some very interesting kind of dynamics in the trust and safety world that we're seeing at the moment, which I think is a world that was interesting and new to me this week. Everything in Moderation was the only media/press who was allowed at the summit. And yeah, so I think I got a kind of interesting look at, the underbelly of the industry at a very interesting time. Hello and welcome to Ctrl-Alt-Speech, your weekly roundup of the major stories about online speech, content moderation, and internet regulation. It's March 26th, 2026. That's a tough one to get out. And this week, we're talking about the major US legal cases that have been announced this week, Meta's big AI moderation push, and frankly, anything else that comes our way. Oh my God, Mike, what has happened?
It's been a week. This has been a week. And I will just say, before we get into our stories, that as we were just about set to record, we got news that the case that Twitter and Elon had filed against advertisers, basically saying it was illegal not to advertise on Twitter/X, has been thrown out of court. We're not covering that. That just came out 30 seconds ago. And we have so much stuff that we were we don't know how we're going to fit everything that happened this week, or really in the last 3 days into this episode, but we're going to do our best.
Yeah. I mean, some podcasters, nowadays do 3-4 hour episodes, and we've been pretty good at trying to keep it tight, an hour maximum.
Oh my God.
Nice and concise. But this is one of the weeks where we could have easily done 3 or 4 hours. We would have needed some energy bars and some Lucozade to do that, or Gatorade, as they say, in your part of the world.
Yes.
So yeah, we have a lot to get through. I wanted to kind of just talk a bit about the summit because I think it's interesting. There is the big TrustCon summit in July in California. This summit in London didn't exist 3 years ago. To be honest, I was kind of skeptical that actually a summit like this could draw folks over from the US, but we saw more than 400 senior trust and safety folks come to London. 2 days of really intense conversations, a bunch of streams throughout the conference, lots of workshops. Not always the most kind of candid conversations, I would say. It was fairly high level at times. Platforms doing their best to kind of talk through what it is they were doing to keep users safe. Very interesting thing for me was that actually Ofcom were not allowed to be at the conference.
Oh.
They gave a plenary, so they spoke at the start of the conference, and then for various reasons, they were not allowed to stick around.
Booted out.
They were booted out. And so I think that kind of summarizes, one of the tensions or one of the worlds that, I witnessed is this, do regulators Are they friendly? Should they be allowed in the room?
Yeah.
What is the kind of relationship the platform should have with them? And I saw a fair range of opinions. Europeans thinking that maybe actually regulators being friendly is a good idea. Folks in the US being a bit more cagey and a bit more kind of worried about maybe having conversations in front of regulators. So very interesting. One of the many, many interesting points of the conference. Yoel Roth was there, who is a former co-host of Ctrl-Alt-Speech. Gave a really good talk at the start of the day about how trust and safety teams should be taking bigger swings and trying to be more innovative, which was a provocative talk at the start of things. So yeah, great to see so many listeners in person as well. I've got lots of really nice comments from people, Mike. People told me that they listen to the podcast while running, which
we got to talk faster. You exercise to the pace of the thing that you're listening to. So you and I have to speak faster. This is a good week for speaking fast.
Yeah. And also, a few folks actually listened while cleaning, which is, again, something we talked about right back at the start. But yeah, it's a part and parcel of a lot of people's weeks, which is great to hear. What have you been up to? What's new with you?
I'm just trying to get through all of this stuff that's happening. I'm about to head off to the Atmosphere Conference this weekend, talking all about the AT protocol and all sorts of fun, exciting developments going on there. So I'm really excited about that. But I got to pack up and get on another damn airplane. I'm seeing too much of the airport lately, and it'll be fun because, TSA is not getting paid. So traveling in the US right now is lots of fun. So that should be an adventure. But there's so much going on this week. It's insane.
Yeah. I was actually reminded by a Charlie Wartzel Atlantic interview that came out a few weeks ago about people making themselves, what he called wearing themselves to death. So it's this idea that everyone's trying to kind of consume as much information as possible and monitor all these different storylines because everything is so chaotic. And I really feel like we've seen that bear out this week with
it depends. There are different things that happen. And obviously there's political stuff that everybody feels like they need to be aware of. I mean, the global situation is a mess in all sorts of ways. And people want to be aware and don't want to miss things. It's not it's not a FOMO situation as much as just there are important things happening in the world. It's probably good to know about them, but you can definitely be overwhelmed.
Yeah. And we obviously try and Ctrl-Alt-Speech to kind of bring you the minimum viable stories you need to know about, the things that, you should pay attention to. And this week is no different. Along those lines, actually, we're going to mix things up a little bit this week. Normally we do two bigger, more meatier stories, followed by a botched attempt to run through a couple of smaller stories. We're not doing that this week. We're not even going to try. We will fail even more so than we usually do. So we're going to do two kind of packages of stories around two big topics that we think are the most interesting things to discuss this week and to chew over this week.
We have a bunch of stories. We're going to link them into two different buckets. And I'll start going in on the first one, which is just a whole bunch of legal stuff in the U.S. related to intermediary liability in all sorts of ways. And so we're going to work through the cases. Most of these probably listeners will have heard of because they've been major headlines and front page news. We'll start with the big verdicts, the two jury verdicts in two different cases, one in New Mexico and one in California, both against Meta. The California one also brought in YouTube/Google. And both of them were sort of big headline grabbing cases where the platforms were effectively held liable for design features that were claimed to cause harm. Mm-hmm. And in both cases, there were fines. In New Mexico, it was a few $100 million. In California, it was just a few $1 million, basically $6 million total between a few different types of damages. A lot of people are celebrating these cases. A lot of people dislike Meta. And, I think that's a justified stance to take, that you don't like Meta or you don't like their platforms, you don't like how they do things. I understand that. But I think that these two cases are really, really problematic. And I think that the results will be bad for everyone. The history of these cases is long, and we don't have as much time to get into them. But the New Mexico case was brought by the state of New Mexico and claiming that Meta was harming people with the various design choices they made. Meta had brought a 230 defense and said, this is all about user speech, and we are allowed under Section 230. We cannot be held liable by a state, by anyone. outside of the federal government for the choices that we make for how we display content. That is, I think, the correct legal position, but the judge rejected it in 2024 and said no and let the case go to trial. And once you go to trial, and part of the trial was very problematic in a lot of ways, because they used internal documents that are taken very much out of context and say things like there were people inside the company or advisors to the company that warned Meta in particular about encrypting Facebook Messenger messages and saying, there are safety risks in doing this in terms of people may use these tools to do bad things, such as sharing CSAM is the major example. And that could be a risk and a problem, and we will have no way to get at that information. And that was a big part of the case. But think about what that means. There's a few different elements to it here. One, the idea that encrypting messages could lead to massive liability, hundreds of millions of dollars, is really bad, because for most people, encrypted messaging is a very important security feature. It protects most people. Yes, some people can abuse it, but just the fact of creating encrypted messaging should not lead to liability. Furthermore, the fact that some safety people raised concerns about this is also something that we should want. We should want companies to be able to have open discussions where different people are raising different things and discussing the trade-offs and allowing the companies to do that. The end result of this, which is that because some people raised this, some people disagreed, but some people raised this, Meta chose to still go forward with encrypting messages, which I, again, think was the right decision. Those documents were used in court as proof, Meta knew this was harmful and they ignored it, and therefore they are liable. So the end result of that means that a lot of companies and a lot of general counsels are now going to tell everybody in their company, never discuss safety stuff in a way that can be written down, taken out of context, and show up in court. That means less open discussion about actually understanding the trade-offs and safety around trust and safety, that we know these conversations happen all the time. We want companies to be exploring these things. We want companies to be able to have open discussions on this. And the result of this case says to most internet companies, don't have those conversations. And I think that will lead to a very, very bad result.
Just on that, does it say, I know that is the kind of a potential outcome, a potential unintended outcome, but doesn't it say, be more mindful of when somebody brings you viewpoints or research or evidence that something might be harmful, be mindful that that decision that you make as a leadership team has implications. Well, it's not saying don't talk about it. It says
but I think it does, because this is the thing, as we often steal from Charlotte Wilner, trust and safety is all about trade-offs and sadness, right? Every decision that you make has trade-offs. Every single decision has some sort of trade-off. And there will be arguments for doing this or not doing this. Each of them will cause harm. And you have to weigh all of those things and weigh other factors and come to a decision. That's what businesses do all the time. That's what all of these companies do all the time. Yes, we can argue that if somebody raises a safety issue, obviously you should take that seriously. But here you have competing safety issues, right? Having encrypted messaging makes a lot of people much safer. It makes their messages safer, and that protects them in lots of ways. Yes, it may also lead to some people using it to do illegal things, including sharing CSAM. And companies are trying to come up with ways to deal with that as well. But there are trade-offs to all of these things. And the fact that the case only shows the one side of it, which is, people raise this. Therefore, the assumption is that as soon as anyone raises anything, you have to act. And there are also safety ideas that people will raise all the time that are not good ideas. And so this case makes that much more difficult. It makes it much more difficult to have an open conversation where you weigh the trade-offs and you talk about them in a free and open manner, because if you can just cherry pick one part of it, then you lose that, it's used against you, the openness of the conversation.
Okay. Let's go to the second case as well and talk about that.
The second case is probably an even bigger deal, even though it was a smaller amount of the fine, which it's known as the KGM case, which is the initials. And there have been many, many cases, and a lot of them brought by the same law firm, arguing that social media is leading to addiction and harmful behavior because of all that. The courts have been just trying to deal with all of these cases, and they set up this concept of a bellwether trial, which is like basically we're going to test these ideas in a trial and see what a jury says. And they actually set up multiple bellwether ones. This was just the first one. So there's still more to come. I think the next one starts in June, if I remember correctly. And so we're going to see a few of these before there's like any sort of final determination, I guess. But again, here, this was a situation where the companies, in this case, there were 4 companies originally. TikTok and Snap were in the case, but they settled right before trial was supposed to start. But Meta and Google stuck it out. And again, they tried at 2:30, and the judge basically said, we don't have to do 2:30 here because this is really about design. And this is what, both of these cases said, this is not about user speech, it's about design. But the reality is that no, it absolutely is about, this is an end run around Section 230. This is an end run about trying to hold the companies liable for content that people don't like on these platforms. And the example that I used in my write-up was like, if these platforms were full of videos of paint drying and they had, autoplay and infinite scroll, nobody would be complaining because nobody watched, right? Nobody would watch that content. It is the content here. And the claim of it's a design issue and therefore it's product liability is a lie. It is only a way to get around the 230 issue and pretend that you're not trying to regulate speech on these platforms. But they absolutely are. But again, like, here you have a sympathetic case. There's a young woman who's very, very troubled. There was a fair bit of evidence that was presented that suggested she had significant trauma from other sources in her life. And it's not that you want to like, how do you parcel out, what things are causing trauma? There was also some evidence presented that her use of social media actually helped her with some parts of the trauma, but may have exacerbated other parts. So how do you separate out those things, right? We've talked about this in other contexts when we're talking about mental health and social media. People use it for all different reasons, and some people struggle with it. And we should look to help, to find those people and to help them. But there are lots of people who are helped by these tools as well, and lots of people who it's neither helpful nor harmful for. And there's this assumption in these kinds of cases that it's inherently harmful, or that if anything harmful happens to a person that can somehow be loosely traced back to social media, that you can sue those companies and make millions of dollars. And then what both of these cases do is they just open the floodgates for anytime anything bad happens and that person used an internet service, suddenly there's this opening for liability. And it effectively takes us back to the world after the Stratton Oakmont case, which was the case about the Wolf of Wall Street firm that led to Section 230 in the first place, which was, in that case, somebody said there was defamation on platform, but because Prodigy moderated to try and make it a family-friendly environment, they said that because you're moderating, you're taking on liability for this. And the fear that Chris Cox and Ron Wyden and lots of other people had was that, like, now this is going to make it much harder for companies to moderate because any decision they make is going to be, they could face liability for it. Now that's the situation that we have. Based on these, if these sort of carry through, both companies are going to appeal and we'll see what happens. There are the other cases. But the sense is like any design decision that you make is now open to have to go through an expensive, very expensive trial. You can argue that, one of the reasons why Snap and TikTok settled early was that like actually going through the trial is super expensive.
Yeah, I mean, this is one of the most interesting points of your tech debt piece, which we'll include in this week's show notes. You kind of run through the argument that you've given there, and the procedural element of this kind of judgment is particularly interesting, right? So explain what you mean when you said you kind of worry about the fact that this could happen to more platforms now that the precedent's been set.
Yeah, this is one of the things that I think is not as well understood about 230. Like the nice thing about Section 230 and sort of the clarity and certainty in theory behind Section 230 is that they get cases rejected early on where they're not that expensive. It's, there are different numbers, but you're basically talking $50,000 to $100,000, which for most companies is not a huge amount. For individuals, obviously, it's a very large amount. But you can get the cases dismissed on those grounds. If you have to go past that motion to dismiss stage, you have to go to what's called summary judgment, which means go through depositions and discovery. You're already increasing the price to millions of dollars. 5 to 10 is generally the range that I hear. Some people will say you can do some of these cases $2 million to get through a summary judgment stage. That's a lot more money, and that adds up a lot quicker for smaller companies. Trial, you're adding a tremendous amount to it. Lawyers cost a lot of money, and trials, I forget the exact, one of these trials took 6 weeks, one of them took 7 weeks. That is a ridiculous amount of money just for the trial process, not even counting all of the prep work leading up to the trial and the motion to dismiss and the summary judgment stuff. These are extraordinarily expensive, many, many millions of dollars that most smaller companies certainly can't afford that. But even if they won, these types of trials would put these companies into bankruptcy.
Yeah, this has been a good week for lawyers.
Yeah,
they're the real winners here, aren't they?
I should have gone to law school.
What's the kind of what is the role of the kind of jury here? Because there haven't been any cases heard by juries to this extent, right? And you mentioned the fact that the Meta is a disliked company. A lot of people don't like Zuckerberg.
Yep.
To what extent has the role of the juries played in the outcome of these cases, do you think?
Yeah, I mean, I think it's, this is the kind of case, and, especially with the California case, they had the lawyers for the plaintiff is kind of a showy lawyer and demonstrative and entertaining. And, really those kinds of lawyers know how to tell a narrative and tell a story that is very convincing to a jury that isn't an expert on the law. Now, the jury is not supposed to be making decisions of law. They're supposed to be deciding factual issues, right? That's the difference. The judge is supposed to handle issues of law. The jury is supposed to determine issues of fact. But those things, which things are issues of law versus which are issues of fact, is often a little bit more subjective than people would like. And in both of these cases, the judges, you could sort of sense, and who knows, I think most judges deserve some level of respect, but it sort of felt that both of the judges in these two cases also kind of felt like, these companies are bad. Let's just send it to a jury and see what they say. And, let them have their day in court is the kind of thinking. But it's such an emotionally charged topic, and it's so easy. The media, I think, has also contributed to this, where they talk about social media as if it is inherently harmful. You have all these stories that suggest that I think have been highly misleading. And you have best-selling books that we've talked about that I think are extremely misleading about these things. And there was a study a few months ago that laid out this idea that actually the media conversation around things like social media addiction was potentially more harmful than any level of social media addiction itself, because it sort of made people think I can't help myself. I can't do anything. I'm in the grip of this awful addictive substance that I can't do anything about. And so I think the framing of this is a narrative that you have this instinctual appeal for it, but the reality is much more complicated. And I really, really am worried about if these cases hold up. We're just going to see a flood of these kinds of cases, and they're going to go after every platform you can think of, many of which are not going to be able to handle it. And it's, we're opening the floodgates here. And I think, a lot of people are comparing it to the tobacco cases and cigarette cases, but cigarettes are inherently harmful. There is no, there's cigarettes are helpful here.
They may look cool.
Yeah, sure. Okay. But this is not cigarettes are putting a chemical into your body that does real damage that we know. This is speech, right? All that social media is speech. And the evidence suggests that it is not inherently harmful. And so all of the comparisons here, I think, are really problematic. And I really worry about these verdicts, even though I understand the excitement over seeing a court say Meta is bad and it's doing bad things to people. There's an emotional appeal to that I totally get. And it clearly worked on the juries as well.
Yeah. I mean, this is, we've talked about the product design piece and the addictive design piece kind of more broadly, and these cases fit neatly into this new narrative that we've seen emerge, right? It wasn't a matter of weeks ago where the European Commission announced that it was investigating TikTok for a number of its addictive design features. It's not just in the US where product design, pro-social design has been deemed to be the kind of vector point for attacking platforms, right? And that's kind of really interesting development that's happened very quickly, I would say.
it's been effective
the last months.
Yeah.
Yeah.
And again, like there's an intuitive appeal to it where it's like we have product liability cases where, the defective design or negligent design come up and you understand that. But here when you break it down, like the negligent or problematic design is like showing you more speech that you like. And that is really worrisome in all sorts of ways.
Yeah. The issue I have, Mike, is that I was at the conference this week and a number of different presentations talked about their safety approach, much like a car. And they said, a car has a number of safety features. It has seat belts, it has a bumper, it has an airbag. No one of these features in and of itself will keep users safe entirely, but the combination of them reduces risks to a kind of manageable degree. And when you buy a car, you buy a brand of car that cares about safety. You're not thinking that you will never crash, but you can undertake that risk knowing what you know. That is what the safety professionals are talking about. And we know that cars are regulated and we know that they are deemed, I suppose, products that need to kind of hit a threshold of safety. How does that chime with these judgments and this idea that we should be thinking of product safety as speech and not as a product?
Yeah. I mean, obviously, I think safety on social media is really important, like a supporter of trust and safety and having that happen. But it's different with speech than cars. Like cars are not speech, right? Like physical products are different. Physical products that can crash, it's a different world. And the trade-offs are not the same. Like the only trade-offs around like safety in cars is like the cost of building in airbags or whatever it is, right? The cost on social media is you're harming some people instead of other people, right? If you're cutting off people from groups, that is a kind of harm. If you're blocking certain kinds of conversations, that can be a harm. There are things around like this idea that, eating disorder content. I've discussed this before, like eating disorder content. Oh, that's bad. That's dangerous. We should cut off those groups. But there were all these studies that showed that when you cut off those groups, it didn't stop the eating disorders. It made people go to more extreme places and made it worse. That the groups that were on mainstream platforms actually had more people in those groups that were helping people with recovery because they would show up and say, I went through this. Here are resources for you. Here's how to help. Or people who would understand you. And that actually led to a decrease in eating disorder as opposed to when they started to ban it and push them to the further edges of these things. It's not the same thing. You can't compare it to something like, should we, have seatbelts or not?
Right. But what I'm saying is if people in the companies are treating it as a product and not as speech, shouldn't they be judged by juries and by wider society for that? Because with all due respect to the people at the conference, and some of them are, some of the smartest people in safety at platforms in the world, they weren't talking about speech, Mike. They were talking about products. They were talking about engagement of products. They were talking about ensuring that the users are safe in the context of the use of those products.
Sure.
If they were talking about speech, then I think the point you're making makes more sense. But that is the difference of what they're saying and what we're judging them for that I always have an issue with.
So, and we have other cases we need to get onto. But what I will say is that, yes, I mean, obviously there are products here and they're making product decisions. But the underlying aspect of all of these social media products or all these internet services products is speech. And so you can't separate out those things. Like, yes, you want them to be thinking of them as products and design, and you want design for safety. You want to think about these things and how do we minimize the harms. But these are things that, again, like every choice is helping some people and harming others. It's not the same as traditional product safety in the sense of a seatbelt or something like that. And so I just think it's an easy analogy to make, but I think it's a dangerous analogy to make. And the result is the cases this week. And I think the potential harm that will come from more such lawsuits.
Yeah. Before we move on, and I know you're itching to do so, I wanted to ask, is there a design-based claim that you would be happy with?
Possibly. I mean, it would really, really depend. I think I haven't seen a really good one yet, but like you could, in theory, see a design where the design is deliberately created to lead to harm. And I don't think any of the major platforms would do this, but like, could you see like some sketchy platform show up that is designed to encourage direct harm. Like the design choices themselves were made not for general reasons of to support the business or, to increase engagement or something like that, but like deliberately designed to say, we want to create as much harm as possible. We want to directly cause people to have eating disorders or something like that. I think you could make a case in those scenarios, but these are always going to be really fringe and extreme sites, not a mainstream site that I can think of.
Okay. So pretty overt product design there. Okay, let's go to the other cases because we are already
I know
30 minutes in.
Well, that actually leads really nicely into the next case, which is the Supreme Court this week did the Cox versus Sony case, which I think a lot of people in the sort of online safety world or intermediary liability world didn't think was that important or didn't even pay attention to it. And in fact, even a lot of the tech companies even weren't paying attention to this case because it felt like it didn't really matter towards intermediary liability for social media because it was about an ISP, which is providing just pure internet service, and it was a copyright case. And that's like a whole other world of cases. You have the DMCA and you have different rules there, and infringement is different than other kinds of things. And yet, I think the ruling could turn out to be really, really important for Section 230 intermediary liability. The decision, depending on how you look at it, was either a 9-0 decision or a 7-2 decision. The really quick basics of the case, to give you the background, Cox is an internet service provider. It's how people get their broadband connection to the internet. Sony, they were sending notices to Cox saying some of your users are infringing on, they're downloading pirated music is basically what it was. And that Cox was not cutting them off fast enough. And the DMCA has some rules about you have to have a reasonable policy to deal with repeat infringers, which works better when you're talking about a company that's hosting. Like those issues come up for like YouTube or stuff like that, or an internet hosting service. It's harder when you're just the connector because you don't hold the content. The content might go through your pipes, but you have less overall say. And so Cox took what was a semi-reasonable position, I think, which was that if they got notices, they would send warnings to the users, and over time they would monitor. And, it took a lot of notices, repeat notices, before they would finally cut you off. I think in the end, they ended up cutting off like 32 people. And Sony said this is not good enough. And the lower courts found Cox liable. They basically said, you didn't do enough to cut people off. There are all sorts of problems with that, like cutting people off from, getting banned from Facebook is one thing. Cutting people off from their entire internet connection is a whole other ballgame. And especially if it was done just on accusations, because it's all just accusations, not like you've gone to court and proven that you've infringed on someone's copyright. It's all accusations. That seems like a really big deal. The lower courts actually did mostly side with Sony, but the Supreme Court said no. And it was a really interesting decision written by Justice Thomas, who I don't often agree with. And Justice Thomas has also been very clear that he doesn't like Section 230 and would potentially like to get rid of it. But a few years ago, we had the Tamna and the Gonzalez case, which were about terrorism. And there was a concern that that case would involve them trying to attack 230. They sidestepped the Section 230 issue in that case. But Thomas wrote this decision around terrorist content and talked about aiding and abetting and what standards you would need to say that Twitter aided and abetted these terrorists, and basically said they would have to take some sort of proactive step. You can't just be like, oh, here's a platform, terrorists happen to use the platform, terrorists do something bad. That is a causal relationship that because you allowed terrorists to use the platform, you're now responsible for the bad thing that they did. And so in this decision, Thomas wrote it, and he basically makes the same argument in copyright law and says for an intermediary to be liable, there's a whole bunch of like specific language, which I'm not going to get into. They have to actually tailor it towards the violation of the law. You have to tailor it to infringe, decide to make things proactively, not just offer a service that people might also use to infringe, but that you have to make explicit decisions to help infringement. And that is another view of liability that matches with what he was saying in the Tamna case. And basically, we're seeing in these worlds that are not protected by 230 specifically, intellectual property is explicitly excluded from it. And the terrorist case, they avoided the 230 question. You have Thomas and most of the rest of the court basically saying to have intermediary liability, the intermediary has to take proactive steps towards this illegal thing. Was what I was basically just saying to you now in terms of like, what cases could you see the design thing be a problem? Here is the Supreme Court effectively laying out what that would be, which is you have to not just have a tool that can be misused by someone, but like actually design it specifically for that misuse and and that harm and that violation of the law. And so I actually think this case may become very, very important because as 230 gets sort of wiped away by these lower courts, if the intermediary liability case comes back to the Supreme Court, you can point to this case, you can point to the Tamna case, you can point to Justice Thomas and say like, hey, you're setting these rules, and therefore you've almost recreated some elements of a 230 scenario, even without Section 230.
Right. So these are kind of collection of rulings might end up replacing 230 in a world where it doesn't exist or doesn't exist in the form that we know it now.
Yeah, possibly. You still have the worry of you lose the procedural benefit of getting it out on a motion to dismiss stage, and it might still be expensive. And so it's not as clean and not as nice as 230. But there is, there were questions in the past, like if 230 had never existed, what would the sort of common law develop around intermediary liability? I had published on TechDirt a few years ago a chapter that was written on a book of internet law pre-230 discussing intermediary liability and what this very experienced lawyer thought at the time. The chapter was totally obsoleted by Section 230, and we've had now 30 years of no development in the case law on it. And so you have to look at sort of parallel cases, and copyright and terrorist stuff are those parallel cases, but we're seeing this sort of law develop on what does intermediary liability look like without 230. And Justice Thomas in particular seems to think, and the rest of the court seems to agree with him, that you have to actually take proactive steps towards doing stuff. And so I'm hopeful. We'll see. You never know. Sometimes copyright is like its own world and never expand, and like nobody ever pays attention to it with other legal doctrines and stuff. But it's interesting to me, and I think potentially a backstop on some of the other court decisions that are problematic right now.
Yeah. Okay. That's interesting. And does Justice Thomas kind of know that?
I don't think so.
Okay.
I don't think he's put two and two together, because like he wrote this really good ruling. Well, not really good, but there were good parts of the Tamna ruling where he basically lays out the reason why we have a Section 230, which is like, without that, if you just have intermediary liability for everything, nobody's going to do anything. That would be really bad. And how can you blame people for things that really other people are doing, and all that's bad? And then, like, a few months later, there was another case where he got to mention how terrible Section 230 was. And I was like, you understand the principle behind it. You just don't seem to connect it to this. So I'm not sure that he puts it all together.
It's like kind of Section 230 has become a toxic brand that is almost the kind of poster boy for what the platforms have done over the last however many decades, right? It does seem to be that's where everyone's kind of ire is focused.
Yeah. So let me go on very quickly. We saw one more big case this week that I want to talk about.
Do it.
And then we get to your bucket. So the other one is the Murthy versus Missouri case, or the Missouri versus Biden case. We talked about it a lot. The Supreme Court heard it. This is the one where like two states, Missouri and Louisiana, and a bunch of random people who were moderated on social media blamed the Biden administration and said that they were censoring the content. You had crazy rulings at the district court, slightly less crazy, but still crazy ruling at the Fifth Circuit. And then the Supreme Court sent it all back and said, there's no evidence for any of this. Over and over again, no evidence, no evidence, no evidence. Actually mocks the district court findings, saying it's based on clearly erroneous findings, and basically says, like, there's no evidence that the Biden administration did anything. Lots of stuff was read out of context, all this stuff. But in sending it back to the lower courts, those cases still went on. There are a couple of weird quirks in here, which is including that, like, one of the plaintiffs, Jay Bhattacharya, is now in the Trump administration and sort of had to drop out of the case because can't be on both sides of the case. And all sorts of other things. Last week, friend of the podcast, Daphne Keller, testified in the Senate, and Eric Schmidt, who had started this case when he was Attorney General of Missouri, started yelling at her because she works at Stanford and he thinks Stanford was a part of this. And we got the classic line from Daphne where he's like, just read the Murthy case. And she just said, the one that you lost, which is just perfect.
Such an own.
Yeah. Oh, so wonderful. And he completely lost his mind. But that case has now settled. and Schmidt and others are declaring victory, and that is utter nonsense. Now you basically have the people who brought that case are in power, so they're settling it just to give themselves a victory. And the settlement is way less than what is being reported or what Schmidt is saying. It only involves the 3 remaining plaintiffs, and it only says that the administration, or like the parts of the administration, like the CDC, cannot put coercive pressure on social media to moderate their content, which
was always the case, right?
Which was always the case. That is the way the First Amendment works. So that changes nothing. And it explicitly calls out in the consent decree that like they can still talk to them and share information and even like alert them to content that might violate policy. Like which is what they were doing all along. This is a complete nothing. But lots of people are declaring victory and people are celebrating. Like X is full of people like, oh yeah. And even people who otherwise like generally have a good sense of this stuff, like Reclaim the Net had an article saying like, oh, the US government has admitted that they censored people. It's like, no, that's not what happened here. So it's important that this case is now over, that we've talked about, but this is a much less, this is face-saving nonsense. It's a meaningless settlement.
Yep. And another reminder of the importance of reporting with nuance and with deep understanding of these issues, because yes, ostensibly those headlines will be true and factual, but they don't tell the full story.
Yeah.
I think that's the closest we've come to a kind of Ctrl-Alt-Speech filibuster, Mike. That was incredible. I mean, I don't know. You could have probably done 4 hours on that on your own, I imagine.
Oh my God. You don't know how much detail and nuance I didn't even get to include in all of these stories, but...
Yeah. When we launched the Patreon, which I've talked to a few people about this week, there'll probably be some of that behind in the premium tier. I imagine. I'm only realizing now, Mike, that actually we should have really warned listeners up front. This is a very meta-heavy episode.
Oh yeah, I guess.
Two big cases with Meta, albeit not on their own. And this next story that I was particularly interested in this week is fully 100% Meta focused. So apologies, listeners, that we didn't flag that up front. The story that I'm really interested in this week, Mike, is the fact that Meta announced at the back end of last week that it's going to use AI more for its user support and safety. And the announcement came out last week, was widely shared. Unsurprisingly, the biggest platform in the world is going to use AI to do a bunch of things related to keeping users safe. The announcement is pretty funny because it really goes very far in trying to claim that AI is going to solve everything. It says that AI is going to help, and I'm going to list the things out, catch more violations, do that more accurately, stop more scams, respond to real-world events faster, and it's going to do so with fewer enforcement mistakes. It's a kind of magic wand, Mike, that Meta is waving here. And look, I'm trying to be open-minded about the potential for AI in a moderation world, right? There are lots of human moderators in the past who've had to watch and scroll through and triage really terrible content online. And AI is a potential way, and has been for some time, but has a lot of potential for eradicating the need for that. And there's a lot of talk at the conference this week about that. There's also increasingly potential for AI to be used to make enforcement much more consistent. And again, there's a few really interesting startups. There's a lot of research at the Stanford Research Conference that you went to last year that suggested that this has a lot of potential. I'm trying to be open-minded, but I do have concerns. And again, we're just going on the basis of Meta's announcement here. We don't know how it's playing out in the back end. This is going to happen over a period of time. But some of the examples they use in the announcement are not necessarily things that AI is newly doing. It talks about catching twice as much sexual solicitation than human reviewers, decreasing the rate of mistakes. There's some sense that AI has kind of optimized systems in recent months and recent years, but this was probably possible before the AI boom that we've seen in the last couple of years. What people are thinking around this announcement is that it's an opportunity for Meta to get rid of humans, reviewers. It's an opportunity to get rid of potentially kind of tools and software and vendors that it uses to moderate content, and that's going to have a cost saving. But actually, whether this is going to be as effective as they're claiming and as the kind of pilots that they've done suggest is, I think, really up for grabs. One of the big flashing warning lights, Mike, in the announcement was actually that it claims that the systems that it's created will be able to do moderation actions for 98% of people online. So it's got a massive language coverage, far beyond the current systems that it has, which cover about 80 languages. We talked about how in the past, in certain countries, Meta doesn't have a moderation system set up that understands the language, that understands the cultural nuance. How will it be able to kind of necessarily judge on a piece of content without that context? It is claiming, quite shockingly, that actually it will be able to do that in 98% of users' cases around the world, which I would love to see. And actually, Mike, in order to kind of test that, I actually asked the Meta AI within WhatsApp, because this was the other half of the announcement, that anybody will be able to kind of go to the Meta AI, will be able to ask, why has my content been taken down? Or why can I not get access to this particular Facebook page? I want to change my password, et cetera, et cetera. And so I asked it, what languages and niche subcultures will this new AI be able to cover, that it wasn't able to cover before? And do you want to know what it told me? It told me about this thing called MetaMind. Okay.
Uh-oh.
So it came back with some snippets of the announcement that I had read with my own eyes. And it also came back with a note about MetaMind. And MetaMind is an AI system for specific industries and professions that it claims will help improve the moderation system and responses that the company has. And I said, tell me more about that. And this is in Meta's own AI system, the thing that will more than likely be aiding users to understand the moderation decisions it makes. And it sent me back a Medium post from a company called Meta House, which has nothing to do with Meta. And I said, hey, like this system that you said will be used in this new magic moderation era that you've just announced has nothing to do with your company. And it said, no, you're right. It's not true. So if that doesn't give you confidence, Mike, that this new AI moderation dawn that has been announced isn't going to be wildly successful, I don't know what is.
I love that. First of all, that is a wonderful example of some of the problems of relying too heavily on the AI stuff. But I will push back a little bit on that too. And this is where, like, I wrote something else this week that I got yelled at about. But like, I think there's this overfocus on like the chatbots. Chatbots get stuff wrong. And talking to chatbots about themselves, they don't have an accurate picture of themselves. They're just trying to have a conversation with you and trying to make it sound legitimate. And in that case, they might pull up false or wrong information like that. I do think that in a more bounded environment where the situation is like you are comparing this content against these policies, that the technology is much better. That, if you're like trying to capture particular patterns and styles of behavior that are inauthentic behavior or are phishing or scams or whatever, the technology is much better at that. I agree that technology does have problems and will make mistakes, but I also think that like the technology is probably better than humans on a lot of these things. And that doesn't surprise me. I think we had Dave Wilner as a guest host on the podcast talking about why he thinks that AI will make my Masnick impossibility theorem obsolete. These technologies are powerful and can be really useful for those purposes. But I do think we do need to recognize maybe they're not going to like cite the wrong company's policies, but they can be bounded in a way that they will be useful, but they will make mistakes, and we're going to have to deal with those.
Yeah, and that's a good segue. I mean, I use the example slightly facetiously, and I'm not a big fan of people who kind of pick out anecdotal evidence to kind of back up a point.
It's too amusing not to mention, though.
I had to say it. I mean, the point is, you will make mistakes. We know that. And the kind of adjacent story that I'll talk about this week is evidence of that, right? So the other thing that I found interesting this week is that one of the ODS bodies that has been empowered under the DSA to do reviews of content moderation decisions, released a report this week. This organization is called User Rights. It is one of the original ODS bodies. It was based in Germany. And over the last few years, it has been reviewing moderation measures that have been submitted by users in the European Union. And the report looks at data that they have collected in 2025. So the number of people who've submitted moderation decisions to them, the number that are eligible, and then it has gone through a review process for as many as it has been possible to do. And this report kind of sums up what they found. So we know that they make mistakes. You're right, Mike. Did you think that as many as 85% of moderation decisions might be incorrect? Because that's what the report found.
But that's not accurate either, right? That's 85% of the ones that were appealed to this board, right? So you're not saying that that 85% of moderation decisions were wrong. People who were wrongly moderated are probably more likely to appeal. So let's frame this properly.
Sure. That's fair. But the point is that we already know that AI is used in moderation workflows, in moderation decision-making. That has been happening for years. My concern is that once a company like Meta ramps up and very much makes public its commitment to using AI in the system, and there is in this case, decent chunk of moderation decisions which have been kind of wrongly rooted and wrongly advised on according to its policies, then that is a concern. If they found that a small proportion of this, is around 3,600 proceedings that user rights looked at, around 3,000 of them were deemed to be incorrect. If there was a very small proportion that came back, that would give me greater confidence about Meta using AI in all of these new ways. That's not the case.
Yeah, I mean, I'm not sure, because I think that, yes, AI will make mistakes, but they may be different mistakes. And we don't know if that will increase the number of mistakes. It will just be different style of mistakes. And the fact that this report, we've seen some of the other appeals groups and their reports, like, they feel like they're under capacity right now. It feels like they could take a lot more cases at this point. I don't know that that's true, but it feels that way, that they're not well utilized. And so, like, if it does lead to a certain increase, like, yes, if it becomes overwhelming, that'll be an issue. But I feel like there's room there right now. And again, like, we'll see how these decisions are made and if they're making more mistakes or if they're making mistakes in a way that are more easily correctable. So I'm a little bit more enthusiastic about the possibility of using AI well for the moderation side, but it is definitely something we should watch. I think the mistakes will be different, and figuring out how we deal with that is going to be a big deal.
Yeah, and we won't dive into it, but there is one more story that's in The Verge this week, and it's about Tumblr, and Tumblr users essentially having many accounts taken down as a result of an automated system, which is a story we've covered many times before on the podcast. That brings me to a close of my little chunk of stories. Maybe it's better without the small story roundup, Mike. I don't know.
Well, we'll have to see. Let us know what you think about this particular episode, which is, yes, the Mike Filibuster episode.
Yeah. Get in touch with us, listeners. Podcast at Ctrl-Alt-Speech.com. Rate, review, like, subscribe wherever you get your podcasts. I had a few people tell me that they were waiting to leave a review and a rating, Mike. Do not delay, listeners. No. I don't know what you're waiting for. Who knows how long this will last for. Tell us what you think. Spread the word. Thanks for listening this week. It's been fun. Thanks very much, Mike. We'll see you soon.
Thanks for listening to Ctrl-Alt-Speech. Subscribe now to get our weekly episodes as soon as they're released. If your company or organization is interested in sponsoring the podcast, contact us by visiting Ctrl-Alt-Speech.com. That's Ctrl-Alt-Speech.com.